I'm Joel Ankney. I'm a lawyer who helps people buy and sell small businesses, and I'm the author of the book, Here's the Deal, Everything You Wish a Lawyer Would Tell You About Buying a Small Business. Earlier this year, I was invited to speak to the Entrepreneurship Through Acquisition class at the Columbia Business School about the legal process of buying a small business. And I'm making this video to share with you the presentation that I gave to the ETA class because I think the information is relevant for anybody who's thinking about buying or even selling a small business. When a buyer calls me for the first time to see how I might be able to help them, they have several burning questions. And in my experience, almost every buyer that I've spoken with has the same questions. So the presentation is organized to answer those questions. And here are the questions that I typically get asked. The first question is, what is my experience? What kind of experience do I have with helping people buy a small business? And that not only includes how many transactions I've done, but also the types of industries that I've helped people buy businesses in. The next question is, when should I engage a lawyer to help me with my acquisition? After that, typically they want to know what my role is in the due diligence process. And then they also want to know what my role will be after due diligence is over and we proceed toward closing. And then there are two big questions that they always want to know the answer to. The first is, how long will it take? How long is it going to take for us to get to closing? And the second question is, how much is it going to cost? What are the legal fees going to be in connection with the transaction? So this presentation is organized in a way to answer those questions. So the first question I want to answer is, what's my experience? I've been helping people buy and sell small businesses for over 25 years. I've worked in big law firms initially doing that, and then I've had my own solo practice for the last 20 years. The transactions that I work on are typically in the neighborhood of $1 million to $5 million in purchase price. On this slide, you can see a summary of the transactions that I closed in 2022. I closed 22 transactions. There were 19 asset transactions and 3 equity transactions. The purchase prices for the deals that I worked on in 2022 ranged from $60,000 for a small martial arts studio to $55 million for a storage facility business that had several locations. Again, most of my transactions, even last year, had a purchase price of somewhere between $1 and $5 million. All of my buyers are self-funded. I have not represented any buyers who asked me to put together a search fund for them or who already had a search fund and then came to me to represent them in the transaction. So again, all of my buyers are self-funded. They also not only are self-funded, but they typically get an SBA loan as well. I usually have 1 or 2 buyers every year who also bring in family and friends as investors to raise a small amount of money to help pay the purchase price. I also occasionally have a buyer who pulls together cash for the purchase price by converting their IRA into a self-directed IRA. That's the ROBS, the Rollover Business Startup, where they hire a company to convert their IRA into a self-directed IRA, and then they pull the money out of the IRA and use that to help pay the purchase price. Typically, my buyers use a combination of funding. They self-fund a portion of the purchase price, they obtain an SBA loan for a large portion of the purchase price, and many times they even ask the seller to take a promissory note for a portion of the purchase price. That's called seller financing. You can see on the slide some examples of industries that I've worked in 2022, everything from construction to e-commerce, financial services, fitness businesses, wellness businesses, healthcare, and real estate businesses. It's August of 2023. I've already closed 19 transactions this year. I have another 5 to 7 transactions that are either in the letter of intent phase or in the purchase agreement phase. Industries that I've helped close transactions in this year include publishing, construction, online, e-commerce businesses, and manufacturing. Here's an overview of the process that I see from a lawyer's perspective. I typically am not involved in the search phase. The buyer does the search on their own, or they might engage with a broker who represents sellers. They might find listings online and they might contact brokers to start discussing the acquisition of a particular business. Often there's negotiation that occurs between the buyer and the seller before the lawyer ever gets involved. Many times that'll be facilitated facilitated by a broker. The buyer and seller will reach a certain point of comfort where they feel like they want to move forward with the transaction and they decide that they want to put a letter of intent in place. This is typically where I become involved, where I help draft a letter of intent or at least review a letter of intent that someone else, such as the broker, has drafted. Once the letter of intent has been signed, we move to the due diligence process. Due diligence could take anywhere from 30 to 90 days. The due diligence period is going to be defined in the letter of intent. During the due diligence process, the buyer is essentially going to take a deep dive into the business, going to look at the financials, tax returns, going to interview the seller, perhaps even interview other key employees in the business, and essentially is going to try and gain as much comfort as possible that the business is worth what the purchase price is, that the buyer is going to be able to operate the business after closing in a way that will service the debt that the buyer will have to borrow to pay for the purchase price. Once due diligence has ended and the buyer has decided to move forward with the transaction, we move to the definitive agreement, to the purchase agreement. At this point, I become much more involved. As the buyer's attorney, I will draft the purchase agreement and submit it to the seller's attorney, and then we'll take several turns as we negotiate and finalize the purchase agreement. During the due diligence period and the purchase agreement phase, the buyer is working with its lender to apply for and obtain its financing. As we get closer to the closing and as the lender finalizes the loan transaction, there will be other transaction documents that need to be drafted that will be signed at the closing. And we'll talk about those a little later in the presentation. There can be anywhere between 10 and 15 additional documents that will be signed at closing, and they each have a particular purpose that I'll talk about. Finally, we'll move to the closing date. At that point, we'll collect signatures, the money will flow, and title to the business will transfer. And then there's a post-closing period, typically where the seller is going to provide some transition services, and money may be held in escrow after closing for indemnification claims, and so at a certain point that money will be dispersed as well. Here's a roadmap to the presentation. I'm going to talk about my role as an attorney in the transaction, the initial legal documents that a buyer and seller will look at. I'll talk about legal due diligence and my role in due diligence. Talk about the definitive agreement, about drafting and negotiating the purchase agreement. I'll also identify and explain the other legal documents that are used for closing, the ancillary legal documents. I'll answer the question about how long it will take, what's the timeline, what can you expect, and then I'll talk about engaging an attorney, and along with that, what you might expect to pay in legal fees. The lawyer has a number of different roles in an acquisition. I wear a lot of different hats. One of the hats I wear is that I'm going to draft and review legal documents. I'm also going to advise my buyer client on whatever legal issues they're worried about or concerned about, or whatever legal issues I think are popping up as we do due diligence and as we learn more about the seller's business. I can help advise on structure, on seller financing, on post-closing transition services, things like that. I'm also a negotiator, so I will negotiate terms and conditions in the purchase agreement and in the ancillary closing documents. Another big part of what I do is act as a project manager. I prepare my own internal closing checklist. There may be anywhere from 25 to 70 or more items on that checklist that need to be accomplished before closing can happen. And so I will work as the person who manages the project, who manages all those tasks to make sure that they all get done. Even if I'm not doing them myself, for example, if the seller attorney needs to do certain things, I'll still be the one who manages those tasks to make sure that they get done on time for closing. Really, the all-encompassing role that I play is a risk manager. I help minimize the risk to the buyer in the transaction. The first document a buyer will be asked to sign typically will be a confidentiality or non-disclosure agreement. They're called confidentiality agreements. They're also called non-disclosure agreements or NDAs. It really doesn't matter what they're called. They have the same purpose, and that is the seller wants to protect the confidential and proprietary information that it's going to be disclosing to the buyer. And so the seller will ask the buyer to sign this confidentiality or NDA. There are a couple of things to look out for when you're signing a confidentiality agreement. You want to make sure that it's mutual. In other words, that it protects information that the buyer is also disclosing to the seller. For example, if a buyer is asking for seller financing, the seller may want to see financial information from the buyer to determine whether the buyer is creditworthy. You also want to pay attention to the definition of confidential information and make sure it fits the transaction, that it fits the industry that you're in or that the seller's business is in. You also want to make sure that it doesn't have any conditions in the definition that might create problems down the line. For example, I've seen confidentiality agreements that indicate where the only type of information that's confidential is information that's actually stamped with a confidential stamp. That's too limiting for me. There's so much information that flows that it would be difficult to make sure that everything has a confidential stamp on it. And you don't want to lose confidentiality protection just because you forgot to put a stamp on something. Also, I like to make sure that the confidentiality agreement pertains to information that was disclosed before the confidentiality agreement was signed. We don't want to get into a situation where information was disclosed prior to the signing of the confidentiality agreement and then have somebody, for example, a buyer, argue that that information doesn't get any confidentiality protection. And then finally, I'm looking at the duration of the confidentiality protection. Typically, the confidentiality agreement will indicate that protection lasts for 3 years or 5 years from the date of the agreement or from disclosure, but confidential information will be disclosed that really doesn't have an expiration date. And so we need to make sure that that type of information is protected for as long as it remains confidential. The other document that a buyer and a seller will sign at the beginning of the process will be a letter of intent. A letter of intent is for the most part non-binding. It's essentially a roadmap of the significant terms and conditions of the transaction. There will be some binding provisions in it, and those protect typically the buyer. The buyer wants to make sure that there's an exclusivity or non-negotiation provision in there so that the seller will essentially take the business off the market for a period of time. It prevents the buyer from getting into a bidding war with other potential buyers. We also want a binding provision in the letter of intent where the seller promises to continue to conduct the business in the ordinary course, to conduct the business as they've historically conducted the business so that the business doesn't drop off. There's the potential sometimes for sellers to feel like once they have a letter of intent in their hands that they can stop ordering inventory, that they can let employees go and not replace them, things like that. And we just want to make sure, as from a buyer's perspective, that we're protected against those types of things happening that could harm the value of the business. We don't want to get to closing and find out that the business isn't worth what we agreed to pay for. Another binding provision in the letter of intent will be the due diligence provision. Again, this will give the buyer a period of time to take a deep dive into the information about the business, the financial information, the operations of the business, etc. During the due diligence period, the buyer is going to use that information to evaluate whether or not he or she wants to continue with the transaction. Everything else in the letter of intent should be non-binding. One of the first burning questions is, when should I engage a lawyer in my transaction? My answer to that question is always, you should engage a lawyer before you sign a legal document. If you're being presented with a confidentiality agreement or a letter of intent, I would strongly recommend that you have an attorney either draft or review those documents before you sign them. Another question, it's not in my burning questions, but a question that I get sometimes is, where do these documents come from? Where do I get a confidentiality agreement, or where does the letter of intent come from? Many times the broker, if there's a broker involved, will have a form confidentiality agreement that they use. They're not always fantastic. That's why you want to have a lawyer take a look at them, but they are starting points. If there's no broker involved, then the best place to get a confidentiality agreement is from a lawyer who does transactional work, who helps people buy and sell businesses. The broker may also have a form letter of intent that they use. Again, that might be a good starting point, but I wouldn't sign it without having a lawyer take a look at it. If there's no broker involved, or if the broker doesn't have a form of letter of intent, then the buyer's attorney typically can supply a letter of intent format that they are comfortable with, that they like. Many times what I like to do is I have a template that I use for my letter of intent, and many times I'll provide the template to my buyer and let them take a cut at the first draft and then have me review it after that so that I can tweak it before they submit it to the seller. And we do that many times when there's a broker involved. The next burning question is, what's my role in due diligence? What's a lawyer's role in due diligence? One of the first things I do once the letter of intent has been signed is I share a due diligence checklist with my buyer client. So this is a checklist that I've compiled over the years from all different sources, including other attorneys. And it's a checklist that helps the buyer ask the seller for lots of information about the business. Once the seller has responded to the due diligence checklist by providing the information, sometimes they provide hard copies, printed documents, other times they provide email document files, PDF files, and sometimes they set up a shared drive in the cloud, a virtual data room that we can all access so that we can see the information that they've disclosed in response to the due diligence requests. Due diligence requests aren't one-time requests. Many times, once we see some preliminary information, we may make additional requests for information. The lawyer's role is to review the information for legal issues. For example, I will review the organizational documents, the incorporation documents, or the limited liability company formation documents of the seller, just to make sure everything looks like it's in line, everything's proper, correct, up to date. I'll also look at contracts that are being transferred as part of the assets. Those contracts might be contracts with significant vendors, significant customers, and leases for brick and mortar space. When I'm looking at those contracts, the primary thing I'm looking for is to make sure that there's no prohibition against transfer of the contract, or if the contract requires that the buyer and the seller obtain the other party's consent before the contract can be transferred. So for example, if there's a lease and the lease says that the lease can't be transferred without the landlord's consent, we need to know that during due diligence so that we know that's going to be one of the contingencies or conditions to closing, is that we obtain that landlord consent. This is also an opportunity for the buyer to determine whether there are any liens on the assets, whether there's any outstanding debt that the seller needs to pay off at the closing in order to get liens released from the assets. In other words, we want to make sure when the buyer receives the assets at closing that there aren't any liens on there that they're going to inherit and have to be responsible for. I may also suggest changes to the deal structure based on the information we see during due diligence. For example, if there are a number of client contracts that cannot be transferred as part of an asset transaction, we may convert the structure of the transaction into an equity transaction so that those contracts will remain in place. And then finally, during the due diligence period, I may also form a special purpose entity for the buyer. The SPE is typically a limited liability company or a corporation that will be the entity that actually takes title to the assets. During due diligence, the buyer is also looking for a lender and submitting loan applications for a loan to fund a portion of the purchase price. I may also help with that process. Once the buyer has made it through due diligence without terminating the transaction based on their due diligence findings, they've decided to move forward with the transaction, then I become much more involved in the transaction, and what I do at that point is I draft a purchase agreement, an asset purchase agreement. The asset purchase agreement is a lengthy legal document. It's the most significant document that's going to be drafted for the transaction, and we're going to focus on a couple of things from the buyer's perspective when we draft the asset purchase agreement. One of the things we're going to focus on is the description of the assets that are being purchased. We want to make sure that we're getting everything we're paying for. We're also going to be looking closely at the purchase price and how the purchase price is calculated and adjusted and paid. This is where we're going to have provisions about adjusting for the value of inventory at closing, for example. And this is also where we're going to talk about paying cash for a portion of the purchase price at closing and then describing the seller financing if there is any. The purchase agreement will also indicate the contingencies that have to be met before closing can happen. For example, one of those contingencies may be obtaining consents from landlords and other contract holders to transfer the assets. Another contingency might be closing on the loan to fund the cash portion of the purchase price. A significant portion of the asset purchase agreement will be the representations and warranties and the indemnification provisions. The representations and warranties are factual representations and promises made by the seller about the business. They'll cover everything from the organization of the business to employees to material contracts to intellectual property, environmental matters. What we're trying to do here is we're trying to make sure that the seller tells us everything they know about the business and remains liable and responsible for any claims that arise prior to closing, even if they arise after closing. The seller's representations and warranties are also going to require that the seller draft disclosure schedules. The disclosure schedules will be attached to the asset purchase agreement before it's signed. And in the disclosure schedules, the seller will have an opportunity to identify and describe any exceptions to the representations and warranties, and will also be asked to list significant factual information about the business. The disclosure schedules are a very important part of the asset purchase agreement because they protect both the buyer and the seller. The indemnification provisions are there to protect, again, both the buyer and the seller for claims that one party is responsible for, but that are brought against the other party. For example, the seller will be responsible for pre-closing liabilities, even if they arise after the closing. So if, for example, a creditor of the seller makes a claim against the buyer after closing for a liability that arose prior to closing, the seller promises that they will reimburse or defend the buyer, make them whole, so that the buyer won't have to be responsible for that particular liability. That just makes sense. That's fair. And the buyer will make similar promises in the indemnification provisions to protect the seller from any claims that arise after closing for the buyer's operation of the business or in connection with the buyer's operation of the business after closing. In some transactions, when the buyer is perhaps not comfortable that the seller will have the resources necessary to cover an indemnification claim after closing, the buyer may ask the seller to leave a portion of the purchase price in escrow after closing. So, for example, in a transaction with a purchase price of, say, $2 to $3 million, the buyer may ask the seller to leave $100,000 or more in an escrow after closing for a period of time, maybe 12 months, maybe 18 months, so that if the buyer has an indemnification claim against the seller, it can make that claim against the escrow. It can get paid out of the escrow money rather than relying on the seller to have to come up with the money on its own after closing. The purchase agreement will also address things that will happen after closing. So, for example, there will be a non-compete restriction that will prevent the seller from competing against the buyer's business after closing. There will also typically be a provision that requires the seller to provide transition services to the buyer for a short period of time after closing. There are also a number of ancillary closing documents that need to be drafted, reviewed, and negotiated prior to closing. The 6 ancillary closing documents identified on this slide are the seller financing promissory note, the personal guarantee that the seller may require the buyer to provide to the seller financing promissory note, the bill of sale, which is a title transfer document for the tangible assets, a proprietary rights assignment agreement. This is a title transfer document to transfer the intangible assets, the intellectual property, the trademarks, copyrights, patents, trade secrets, know-how, etc. An assignment and assumption of contracts. If there are contracts that are being transferred as part of the assets, for example, significant contracts with vendors or suppliers or manufacturers, significant contracts with clients, customers. This is the document that will transfer title to those contracts from the seller to the buyer. If there is a brick and mortar lease, for example, that needs to be transferred from the seller to the buyer as part of the transaction, there will be a separate lease assignment and assumption agreement. There will be a separate non-competition and non-solicitation agreement that the buyer will require the seller to sign at closing. If there is a post-closing escrow for indemnification claims, there will be a separate escrow agreement that's signed by the buyer, the seller, and the escrow agent. There is also typically a consulting agreement or transition agreement that is signed at the closing where the seller promises and agrees to provide certain transition services to the buyer after closing. Corporate resolutions that need to be drafted and signed at closing that authorize either the purchase or the sale of the business. There will be some certificates that are drafted and signed at closing. A certificate called a bring down certificate, for example, which basically says that if the asset purchase agreement was signed prior to the closing, maybe a couple of weeks or a month prior to the closing, that the representations made in the asset purchase agreement were true not only when the asset purchase agreement was signed, but they're also still true on the closing date. There will also be an entire loan packet, if there is a lender involved, a packet of loan documents provided by the lender that will have to be signed by the buyer, who is the borrower, at the closing. You may wonder why there are all these different ancillary documents, why the asset purchase agreement doesn't accomplish what these ancillary closing documents accomplish. One of the reasons why some of these documents are necessary is because they are title transfer documents. For example, when you own a car or a house and you want to sell that car or the house, there is a title transfer document that already exists. The car has a title to it and a house has a deed to it. And so when you sell a car or a house, one of the things that you deliver to the buyer is the signed title to the car or a new deed that's signed by the seller to transfer title over to the buyer. In an asset purchase transaction, there are no title documents, and so we have these ancillary closing documents to transfer title to certain categories of assets. Another reason why we have separate ancillary closing documents is because if a dispute arises after closing around one issue, for example, if the buyer thinks that the seller is violating the non-competition restriction, we'd much prefer to bring a separate non-competition and non-solicitation agreement before a court than to bring the whole asset purchase agreement before the court. Another legal reason for having separate documents is that there is an old rule, and it may or may not apply in certain states, that if one provision of a contract is invalid or unenforceable, that makes the entire contract unenforceable or invalid, and we want to avoid that. There are other ways we try and avoid that with some of our drafting language in the asset purchase agreement as well. Another reason for having a separate ancillary closing document related to the transfer of trademarks and copyrights is because if a trademark or copyright is registered with the federal government, part of the transfer of that trademark or copyright involves recording the transfer document with the U.S. Patent and Trademark Office or the U.S. Copyright Office. And again, we don't want to record the entire asset purchase agreement because the recorded document becomes public record, and we don't want people to be able to see all the terms of the transaction. So instead, we have this separate document that we can record, and the public can only see the information that's in this short ancillary closing document. All right, one of the most significant burning questions is how long will it take to close a transaction? I have had clients call me and say they want to close a transaction in a week, in 2 weeks, 3 weeks, 1 month, 2 months, 30 days, and many times they just ask me, how fast can we close? When I showed this slide to the Columbia Business School ETA class, it was the slide in the presentation that got the biggest reaction. I think people were surprised at how long it may take to close the acquisition, the purchase of a small business. I tell buyer clients to plan on needing at least 4 to 6 months to close the transaction. That's 4 to 6 months from the date on which the letter of intent is signed until the closing date. Now, this slide gives you an idea of how long it might take to do certain things. It doesn't take very long to get a letter of intent in place. Due diligence might take anywhere from 30 to 90 days, depending on what due diligence period you get in your letter of intent. Financing typically takes quite a while. If you have to go to a commercial lender to get a loan, there's a loan application process, there's an underwriting process, and then there's a loan documentation process, and then a loan closing. Drafting, reviewing, and negotiating a definitive agreement, a purchase agreement, can take a couple of weeks or even a couple of months, depending on how complex it is and how much difficulty there is during the negotiations. Drafting and reviewing and negotiating the ancillary closing documents typically doesn't take too long because you're essentially drafting those documents based on the information contained in the asset purchase agreement that you've already negotiated and finalized. Closing the transaction typically doesn't take very long because what we're doing there is collecting signatures, initiating wire transfers, and dispersing funds to pay off creditors and to pay the seller. There are a couple of factors that typically slow down a transaction. One of those factors might be the complexity of the transaction. For example, if you're a buyer and you need to do a private placement to raise some money from investors, from friends and family, you're also getting an SBA loan, you want to do some seller financing, and maybe it's not an asset purchase deal, but now it turns into an equity transaction and you want the seller to stay on for a longer period of time after closing. All these complexities requires a lot more structure, a lot more drafting, a lot more negotiating, a lot more planning, and that can take a lot more time. So complexity of the transaction can lengthen the amount of time between letter of intent and closing. Lenders also may lengthen the amount of time needed to close a transaction. They need to go through the application process, the underwriting process, and the documentation and closing process. Many lenders have a high volume of loans that they're working on, and their loan processors are working on multiple loans at the same time, and so they just may need more time to get through your loan and to get you to closing. If you need to get consents to transfer leases or significant contracts, getting those consents can slow things down. Landlords typically don't put transfer consents at the top of their to-do lists, and they don't know the buyer typically, and so they may need time to vet the buyer, look at their credit history and their financial strength. And so when you're working with landlords and other contract parties to get consents, it's going to take a little bit more time. And finally, lawyers. Lawyers can also slow down a transaction. For example, if a seller decides to engage a large law firm to represent them in the transaction, that law firm may treat the transaction in the same manner that it treats a much larger transaction. Large law firms typically are used to working on large transactions, for example, over $100 million in purchase price or even $500 million or more in purchase price. And they have a process for doing that, and it's very complicated. And I have had an experience with many large law firms on the other side. They're wonderful lawyers, but they work a small acquisition or a small sale in much the same way they work a large transaction. For example, earlier this year, I closed a transaction where the purchase price was between $15 million and $20 million. I was representing the seller in the transaction. The buyer was represented by one of the largest law firms in the world. The buyer's law firm staffed the transaction with at least 7 attorneys that I know of, and just working through the transaction with all those attorneys took a significant amount of time. The reality is that lawyers also are working on multiple deals at the same time, and depending on their workload, they may not be able to respond as quickly as you would like them to respond. In those situations, I think the best way to handle that is simply to continue to communicate with your lawyer, communicate expectations, and listen to their input on the speed of the transaction as well. So finally, how do you find a lawyer to help you with your small business acquisition? There are a couple things I think you should keep in mind. One is that you should find an attorney who has experience handling small business acquisitions and sales. There are many attorneys out there who are wonderful trial attorneys, but in my experience, litigation requires a different skill set and a different approach than handling a transaction. I recommend that you look for somebody who has experience handling business transactions. Now, you'll likely see on website bios that attorneys have experience in both litigation, trial, etc., and business transactions, but I think you really need to interview the attorney to understand their experience. You'll also want to look at their demeanor, their approach to handling transactions. Are they deal makers? Do they try and facilitate the deal, keep the deal moving forward, or are they adversarial? Is every issue a significant battle? One of the things I think a good transactional attorney can do is to help you filter issues. Which issues are more important in negotiation? Which issues can be abandoned or given up in exchange for something else? If the attorney's approach is to treat every issue as a significant and serious issue, in other words, they don't make any differentiation in the weight or the the seriousness of the issue, that may slow the deal down. That may make negotiations more difficult. My approach is when I have a willing buyer and a willing seller, I assume that the intent is that everybody wants to close the deal, and I'm going to work with them in a way that will help them get to that objective. Do you need an attorney in a big law firm, or can you use an attorney in a small law firm? Well, I'm a little biased on that because although I spent the first 12 years of my career at big law firms and had wonderful experiences there and received a lot of good training and worked on a lot of interesting and complicated transactions, I've been a solo attorney for the last 20 years, and I've been able to bring the experience that I received at the big law firm to smaller transactions. I think there is a possibility that you could over-lawyer a transaction, and what that'll do, it'll increase the time likely that you'll need to close. It may also increase the difficulty of the negotiations, and when you use attorneys at big law firms, your legal fees are just going to be higher. Where do you find a lawyer to help you with your acquisition? You certainly can do online research, look at people's websites, you can look at their ads, but I think one of the strongest ways to find an attorney to help you with your transaction is to ask for a referral. So for example, if you have a trusted business partner or a trusted accountant, or if you know a lawyer who perhaps is a trial attorney, you can ask those individuals if they have somebody that they recommend or that they can refer to you who can help them with their transaction. Almost all of my clients come to me because they've been referred to me by someone else, either another attorney, an accountant, a business broker, or a client that I've represented in an acquisition in the past. I suggest you identify a couple of attorneys, 2 or 3 or 4 attorneys that you want to interview about representing you in the transaction, and that you have either an initial phone call with them, a Zoom call, or even a meeting with them to understand who they are, if they fit well with you and your transaction, and to understand their approach to negotiating and closing acquisitions. The last burning question is, how much is it going to cost? What are the legal fees going to be? I've been doing this for over 25 years. I've handled many transactions with a purchase price between $1 and $5 million. When a potential buyer calls me and we go through these burning questions and we get to this particular question about how much it's going to cost, I do ask a couple of questions. Questions like, what's the purchase price? How are you going to finance the purchase price? How are you going to pay the purchase price? Are you getting an SBA loan? Are you looking for private investors to help you? All those things help me understand how much legal services need to be provided in connection with the transaction. But for the most part, I know that based on my hourly rate and the time that it takes me to help a buyer with a transaction, that if they have a transaction that has a purchase price of between $1 and $5 million, they should budget between $12,000 and $15,000 to pay for legal fees. Now, sometimes my legal fees are less than that. Sometimes they might be a little bit more, but typically that's a great range to start with, and it's going to vary just based on all these factors that we've already talked about: complexity, lawyers on the other side, lenders, landlords, things like that. I have prospective buyers who ask me how I determine my fees, and I do it the way that attorneys have done it for so many years. I have an hourly rate, and I simply keep track of the time that I work on the project, and then my legal fees are basically the amount of time I worked multiplied by my hourly rate to determine the fees. Now, some people don't really like that because they think that gives me an incentive to bill lots of time. What I tell people is I've been doing this for a very long time. I wouldn't continue to get a lot of clients and business if I became known for a person who overbilled or padded my time. And so you need to trust me that I'll use my reasonable discretion on determining what's fair and how much time I need to spend on different aspects of the project. People will ask me if I'll take a flat fee, if I'll take a contingency. The answer to those questions is I haven't become comfortable enough at this point with those alternative billing approaches. I've heard of other transactional attorneys who will take flat fees, but I've also learned that those flat fees are typically much higher than the estimated fees that I quote my potential clients. So if you want to pay me a much higher flat fee than what I quote for my estimate, I guess that could be okay with me. But Again, that's not my style. From a contingency perspective, it doesn't really make a lot of sense to take a transaction on a contingency when you're representing a buyer. A contingency means that I would take a percentage of, for example, the purchase price as my fee. It doesn't make a lot of sense from a buyer's perspective. It may make a little bit more sense from a seller's perspective. But again, if I were to determine what that percentage would be, I think I would, because of the risk involved of not closing the transaction, that percentage would probably be high enough that it would exceed the estimated hourly budget that I quote to people. So I just stay away from those at this point. A related question to the fee question is, when does the fee get paid? I leave that up to my clients typically. Many attorneys like to get paid on a monthly basis, and I give that option to my clients, and some clients take it. But one of the other options I give them is the option to defer my fees until the closing. Many times buyers like to defer my fee to the closing because they're going to pay my fee out of the loan proceeds they receive at the closing, and I'm okay with that. Thank you for watching my presentation. If you have more questions or want to learn more about the process of buying or selling a small business, you can see my contact information here on this last slide. If you want to buy my book or listen to the audiobook, you can find the print book on Amazon and the audiobook on Audible. I also maintain a blog at my website, so if you have other questions, you might look there first to see if you can find an answer there. Thanks.